Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Today, in order to understand the case against President Trump and the Mar-A-Lago, the whole raid and all that stuff, we have to understand the Presidential Records Act. Under the Presidential Records Act, incumbent presidents have exclusive responsibility for the custody and management of the presidential records while they are in office. The National Archives and Records Administration has no formal role in how incumbent presidents manage their records, except if a president decides, hey, I want to dispose of these records. NARA provides guidance and counsel to the incumbent presidents and their designated officials upon request, because some things should not be destroyed. In other words, while the president's in office, he alone has control over the administration's records. After that, the PRA and the records become the property of the National Archives. Now, each change in the presidential administration requires a massive move of records and materials. NARA plays a key role in the transfer of hundreds of millions of textual, electronic, audiovisual records and artifacts from the White House to an outgoing president's future library. So, for example, if the King of England gives Joe Biden a sugar bowl with Queen Elizabeth's picture on it and accepts that in the course of being the President of the United States, that does not belong to him. It belongs to the United States, and it goes into the archives when he leaves. Or it may go to his presidential library if one gets built. All of the records and documents and things that are in that library are not the property of the president or the 501c3 not-for-profit that runs the library. They are instead the property of the National Archives. NARA also plans for the transfer of legal custody of materials when an administration ends. The care of those materials, the development of the library itself, are all under their guidance and discretion. Presidential records come to NARA at the end of an administration, period. The Freedom of Information Act applies to presidential records. 5 years after the president has left office, they become eligible to be seen under the Freedom of Information Act. NARA uses that 5-year period to begin to conduct archival processing and otherwise prepare for the onset of public access. Now, what's archival processing? They're going to run all of these things through a microfilm camera, and they're going to microfilm as much of this as they can possibly do. And the reason for that is pretty simple. When Mr. Researcher comes to the library and, hey, I want to look at President Trump's records, or I want to look at President Nixon's records, it is far easier to hand them a roll of microfilm and have them go through it on a microfilm reader where they are not physically touching the documents themselves, because oils from your fingers and other things like that, exposure to light, exposure to room air, all of those can damage a record once it's supposed to be preserved. Now, there are ways that they can preserve some documents for historical access, but even those are usually not something you can just walk up and touch. Now, why is all of this necessary? Why do we have the Presidential Records Act? Because the presidential records of many prior administrations are lost to history. Wouldn't you love to know what was said, what the meetings were like between Harry Truman and his cabinet over whether to drop the bomb on Japan? Without access to those records, that information would be lost. So, as a guide to future presidents and their decision-making, as well as a guide to historians to help write an authentic and authoritative history on the United States, those documents are preserved in the National Archives. The way they are preserved and the way they are made a piece of property of the United States is through the Presidential Records Act. That was passed in 1978, and the very first administration that was subject to the requirements of the Presidential Records Act was the Reagan administration. And here's what the Presidential Records Act says. This starts with the definitions section. The term documentary material means all books, correspondence, memoranda, documents, papers, pamphlets, works of art, models, pictures, photographs, plats, maps, films, and motion pictures, including but not limited to audio and visual records or other electronic or mechanical recordations, whether in analog, digital, or any other form. The term presidential records means documentary materials or any reasonably segregable portion thereof created or received by the president, the president's immediate staff, or a unit of the individual of the executive office of the president, whose function is to advise and assist the president in the course of conducting activities which relate to or have an effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president. Such term includes any documentary materials relating to the political activities of the president or members of the president's staff, but only if such activities relate to or have a direct effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president. But B does not include any documents, materials that are official records of an agency, as defined in Section 552 of Title V, personal records, stocks of publications and stationery, or extra copies of documents produced only for convenience of reference when such copies are so clearly identified. The term personal records means all documentary materials or any reasonably segregable portion thereof of a purely private or non-public character which do not relate to or have an effect upon the carrying out of the constitutional, statutory, or other official or ceremonial duties of the president. Such term includes, but obviously isn't limited to, diaries, journals, or other personal notes serving as the functional equivalent of a diary or journal which are not prepared or utilized for or circulated or communicated in the course of transacting government business. Materials relating to private political associations and having no relation or direct effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president, and materials relating exclusively to the president's own election to the office of president, materials directly relating to the election of a particular individual or individuals to federal, state, or local office which have no relation to or direct effect upon the carrying out of constitutional, statutory, or other official or ceremonial duties of the president. So those are the definitions that guide what are the presidential records and what are the personal records, because those are the two terms that are most at issue in this case. So the legislation took effect in January of '81. Like I said, Reagan was the first president to have his records cataloged under that act. There are different types of presidential records. I mentioned them earlier. Textual records. That includes letters, memos, schedules, briefing papers, and publications. And then there are electronic records, email messages, electronic files, word processing files, spreadsheets, digital images, social media content, and digitized content. A letter from the Queen of England to Barack Obama relating to his visit to England would be a presidential record because it relates to his presidential duty. A letter from a British subject, some guy on the street, to President Obama, congratulating him on the Nobel Prize, would likely not be because it doesn't relate to his official duties. It relates to an honor that he received, so he could keep that as a personal record. Now, the Nobel Prize materials would be a presidential record because they relate to a ceremonial duty of the president, which is, of course, receiving that Nobel Prize. And again, audiovisual recordings, those are pretty easy to understand. The Presidential Records Act also applies to vice presidents, and all of their records have to be turned over to the National Archives and Records Administration at the end of their administrations. I'm not sure that is explicitly followed by everyone. The Presidential Records Act requires the president to separate personal documents from presidential records before leaving office. So in the last year of a two-term president's administration, generally speaking, there is someone who says, okay, I need an hour of your time, Mr. President. Let's look through some of these records and decide which ones are personal and which ones are not. And at that meeting, you're going to have the president, you're going to have a member of the National Archives, most likely, you're going to have legal counsel to the president in case they have to argue over the status of a particular record, and then you're going to have the factotum who's busy just pulling things out of the box and handing them. So the reason that they require the president to do that before the end of his term in office is because once his term ends, it's the responsibility of NARA to take custody, control, and preservation of those records. There's no history, practice, or provision in the law for presidents to take official records with them when they leave office to sort through, such as, some people have claimed that there's a 2-year period. That's not true. If a former president or vice president finds presidential records among their personal effects, they are expected to contact the National Archives Records Administration in a timely manner to secure the transfer back to NARA. The PRA also requires that all documentary materials be categorized as presidential records or personal records upon their creation or receipt and be filed separately. So you cannot intermix personal records with presidential record. So if it's part of the job, it's a presidential record. If it pertains to what the president was doing trying to get elected or something like that, it is a personal record. And the moment it's created, when the president gets that letter from the guy in England, it is immediately segregated over and kept in a different file cabinet because it is declared to be a personal record at that point. So what can we learn from all this? First, presidents don't get free rein to decide what is and what is not a presidential record. That job belongs to the National Archives Records Administration and, to a certain extent, the president's private legal counsel if there is a question. Again, if it relates to an official duty, it's a presidential record. So a letter from Kim Jong-dong Wang Feng in his official role as the dictator and supreme murderer in North Korea telling Trump they had a beautiful meeting is in fact a presidential record. Now, keep in mind there is no problem, assuming that it's not classified, with the president keeping a photocopy of an official document. He can keep an electronic copy of that document in his personal files. But the actual letter signed in the blood of his enemies by Kim Jong-Wang or whatever his name is in fact a presidential record. In the next video in this series, we'll look at the espionage statute and the elements of the crime of espionage as it applies to Trump. One personal note that I think needs to be said: back when my brain was about 40 years younger, my office looked pretty much the way it does today, but I could find any document I needed just like that. Nowadays, not so much. I am a terrible record keeper, and were it not for my wife, tax time would be an exercise in rampant speculation. So I am in no position to criticize President Trump on his record keeping, but honestly, keeping classified documents in a cardboard box in your residence after you've left office, even though you still have a clearance and you still have the ability to access classified materials, isn't very smart. Trump was not well served by either his legal counsel or his personal staff in the move from D.C. to Florida. Competent attorneys would have insisted that he turn over all the classified documents, and I think he did not exercise the best judgment in retaining a lot of these records. Now, does that reach a level of criminality? I don't know. We'll let the jury decide that. But there is no criminal penalty associated with the PRA or violations of it, other than you could, I suppose, make a case for theft of government property, but that's fairly unlikely given the fact that if he put up a presidential library, all of those documents would be able to go to the presidential library, and you'd have to show that he intended to prevent the government from ever getting those documents, which, again, I'm not certain they can do. The next video is the really important video, and I'm working on that right now. Hopefully I'll have something for you shortly on that. But until then, thank you for watching this video. If you have the opportunity today, reach out and do something nice or kind for someone. It is a way that we can help change the world one kind act at a time. And of course, if you have questions, drop them in the comments down below. Like, share, subscribe. You can email me at the address above. And as always, come on back here tomorrow and reach me at the beach and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.